collector used to estimate the amount of current year taxes by deducting the credits and then multiplying the remainder by the marginal tax rate. For example, say a veteran had only SISIP at $4,000 a month for $48,000 a year and a 20% tax rate. Take off the personal tax credit and the disability tax credit. Now I'm estimating, so I'm assuming that he has the disability tax credit. And the personal tax credit applies to everybody. Now I just put in arbitrary figures just for the sake of the comparison. So I said that's about $12,000 even. So that would leave $36,000. 30A is meant to guard against government excessive collection and a waste of taxpayer resources. Now, it's really simple, and you can use different words to get the message across. For example, Treasury Board Secretariat put out a policy on this over-collection of information, and they said it was to prevent response burden from the citizen. Well, you can state that response burden by saying, listen, when we put Section 82A into the Privacy Act, we meant to allow us to share information for a similar purpose, and that is common sense. If the government already has information on hand at, say, the Department of National Defense, and then, say, the Veterans Affairs Department needed that information, and if it's for a similar program, and there is a program arrangement between the Department of National Defense, SISIP Financial Services, and Veterans Affairs Canada. So they signed a program arrangement for the Service Income Support Insurance Plan and the Earnings Loss Benefit, which is now the Income Replacement Benefit. So it is not available for them to say these are not similar programs, therefore we had to protect people's privacy and we can't share information under Section 82A of the Privacy Act. Now, again, when I was going through my phone, my old phone, not the one I'm doing this video on, when I was going through my old phone this morning for pictures and stuff when I was bored, I saw Section 80 of one of the acts that Veterans Affairs administers. I don't know which one it was exactly, but it said that the Privacy Act did not matter when the Minister of Veterans Affairs wants personal information. He can ask for it and get it. Therefore, that bullshit about consent, when they say, oh, we can't share things without consent, and Section 82A is not applicable at all if they wanted to enforce the fact that basically, like many other statutes, I think it was over 40, maybe 42 different laws, the minister is given the powers of an inquiries commissioner. Now, that means that they have the power to compel evidence because they want it. So because the government put those laws, those sections in those laws, it isn't available for the government to say, well, we can't share the information. Well, if Veterans Affairs wants something, and I'll give you an example from my case. They sent me a form called a VAC 928E form, and that was a consent to share information between the Department of National Defense Service Income Support Insurance Plan and Veterans Affairs Canada. Now, given the powers given to the Minister of Veterans Affairs under Section 80 of that Act, they didn't need my consent. So when I sent it in, and then they lost it, they said they don't have it anymore. But I found a copy of it under the Privacy Act, which is ironic. I found a copy of when they sent it to me, and then I sent it back to them, that they received my VAC 928E consent form. Now, I've talked about that a whole bunch of times, but the fact of the matter is that they had my consent, and I don't know if they exercised it, even though they didn't need it. Now, carrying on, I look up the SISIP et al. Annual reports, as I have not done so in recent times. Now, again, I was going through my photos today, and I saw several of the disability insurance, which is planned to 12,500 G for the Treasury Board Secretariat this morning. Now, that policy has had surpluses many times, and they've had payment holidays, contribution holidays. I don't think the SISIP plan ever had holidays. I don't know. But if they did, the government would save the most of the money, not the soldier, because 85% of the premium on paper is paid by the Government of Canada. Now, on that note, just because something is paid by someone else doesn't mean it's meant to be paid for them. the payment, it said, and I believe they were quoting the Marzetti versus Marzetti Supreme Court of Canada 1994 case. They said, you know, assigning someone the right to get some money doesn't matter until the right to the money materializes. Now that's a fancy way of saying we'll cross that bridge when we come to it. So you can't assign the right to something until you actually get it. That's common sense, right? But the insurance companies across Canada estimate Canada Pension Plan, Disability, and SISIP manually tried, I don't know if they succeeded, I can't recall, with Ashley. That is insane. Now, like I said, that's just too off the top of my head. I'd have to go through my records, go through my instant message, and see how many people I've discussed things with over the past, 5, 6, 7, 8 years. Document the reasons for the Manouche Federal Court 2012 case being incorrect in law with respect to indemnity. Now that's a topic I'm always talking about, indemnity. If you get indemnified something, and you can get indemnified for your time if you get paid for your service, that's called income. If you get hurt and somebody indemnifies you for your loss, then you were paid damages to make you whole for what the damage they caused to you. Now, the Pension Act is an indemnity for your injury in Canada's military service. But they got rid of it in 2006. No new pensions have been awarded since 2006. Now, they claim they compensate people under the Veterans Wellbeing Act, which used to be called the Canadian Forces Members and Veterans Reestablishment and Compensation Act, which is quite a mouthful. The thing is, though, they don't understand, I think, what compensation means. Compensation is supposed to mean, in the context of injury, the same as indemnity. So if you get compensated, you are being indemnified. Now, if you're getting indemnified for an injury, you're getting compensated for an injury, it has nothing to do with income. It has to do with a capital payment to replace the capital loss that you suffered. That's the way it's supposed to work. Now, Pension Act, Section 25, that has clawbacks for at least two things. First of all, if you sue somebody who hurt you and you get the Pension Act for the same injury, then they will claw back 50% of the damages if you sue somebody else other than the government. And if you sue the government M1, they will claw back 100% of the damages because you sued the government, which I say is bullshit. You can't have two different laws on the same thing. You can't. It isn't part of income. That's a major. Well, duh. It's not income from an employment where you sign a contract with the employer. You give this employer service. You get paid for your service. You both benefit because the employer makes a profit based on your work, and you make a profit because you worked. That's income. But if the employer had an insurance policy that it got Manulife to administer, but it underwrote the policy, you're not getting money in relation to your current service. You're getting a payment, if they approve you, in relation to the premiums you paid to buy a contract of insurance. That's not income. Despite the fact that they might call it income, it isn't income. It's insurance. I feel stupid repeating all these common sense things. I mean, country. So if they want me to sign something that I can't take back, I'm not signing it. Okay? That's it. I'm not signing it. Now, Sun Life estimated my Canada Pension Plan disability prior to my approval because they said I didn't apply, but I did apply. I just didn't sign the irrevocable consent form. So I applied for the Canada Pension Plan, but I didn't sign the form for them to get the payment. I got the payment instead. They don't like people screwing up their racket, their scam, their fraud. Manulife sent me a bill for the same money. Recently I thought of something, and I'll share it here. I was going to put it in next week's show, but I presume I signed a condition of benefit agreement with Sun Life, back in 2008, 2009. So Manulife would have been second in line if I had signed the second condition of benefits agreement, which the judge said in the Manouche case didn't matter. Basically, the judge said that duress was involved because people had to sign it as a condition of benefits. Then, read between the lines. The signature on the document doesn't matter. Now, I've been thinking a lot about this. You can tell. I hope. I'm not just spouting off stuff off the top of my head. I've been researching this for years. One of the most key elements in a contract is consideration. Even if two people agreed to something, if no money changes hands, it isn't a legal contract. Now, the condition of benefits agreement is not a contract. They only get you to sign something, and then they want you to hold you to your signature without money having passed between the two parties. It has no legal value. Zero. In fact, it could be a huge liability for the insurance companies that make people sign these things because they don't pay or they don't get paid. I don't know if it matters which way the money flows, but there's no money flowing for signing these condition of benefits agreements. Now, before people say, well, Matt, what about the long-term disability payments that you got? They had to be paid anyway, as per the contract. And past consideration, if someone said to you or me that, you were getting payments right up to whatever, and we're going to cut you off because you didn't do the condition of benefits agreement, you wouldn't agree to it because you said there's no money passing hands. Past consideration doesn't count towards the formation of a contract. See? So what these people are doing one of these days when people start listening to the things that I say is that it's putting them at risk of punitive damages, because they're representing that they will not pay unless you sign this agreement. But they don't pay, or they don't ask you to pay, for the signature. Speaking of signatures, another thing I want to look up, seeing I'm talking about it, if I recall later, I don't think the SISIP policy 901-102 has signatures in it. But I'm pretty sure when I looked through the Great West Life policy that the RCMP signed in 1978 or so, that has signatures in it. I know that the effective control agreement signed by the Chief of Defense Staff in 1990 on the 1st of March, that had signatures on it. The program arrangement between the Department of National Defense, the Department of Veterans Affairs, and SISIP Financial Services had signatures and dates on it. The government is trying to say that there is a contract of insurance between us and Manulife when there's no signatures in the contract, and on paper the contract states that it's an agreement between the Chief of Defense Staff and Manulife. Now, if there's an agreement between the former employer, the Chief of Defense Staff, and Manulife, that doesn't involve us. You can't hold a third party to an obligation in a contract when they had no part in the formation of said contract. That just isn't how contract law works. To be bound by a contract, you have to be a party to the contract, and you had to have negotiated some say in the contract. I mean, these people are just lording it over us and getting away with it. And I believe I'll take this to my grave, and you can agree or disagree. It has to do with the indoctrination of soldiers to instantly obey a lawful order. They want to be able to say, if you question it, it's in the contract. And they hope you go away because it's in writing in the contract, and therefore you won't question it anymore. Tell me if you agree, if you have a different theory. But it has to do with the instant obedience, the habit of obedience. They don't want soldiers thinking for themselves. Nobody would agree that, you got to have a meeting every time something happens. If you're on the battlefield, you got to make quick decisions, and you can't have a democratic system. It's an authoritarian system. The person with rank orders people to do. They might be wrong, but they have to make a decision. Now, last point. Should the Old Age Security Act be easy to change? I answered my rhetorical question, no. Pensions should be hard to change. Look at the Canada Pension Plan Act. The Canada Pension Plan Act is designed to be hard to change. They said that you had to have 7 out of the 10 provinces with 67% of the population, or you cannot make major changes to the Canada Pension Plan Act. Well, I think the Old Age Security Act should be the same. People might say, why? Well, it's supposed to be part of our retirement system. So when they want to change it, like they changed the age of retirement to 67 under Harper and Mulroney, he changed it so they don't pay it to rich people. That brings up problems. How do you define rich? Somebody decided that it's going to start at $78,000 and end at about $128,000, something like that, a $50,000 band. But where did they come up with those figures? Is it arbitrary? Did they do some study on all that? What exactly are they going to include? Will they include the Veterans Wellbeing Act payments? Will they include the Pension Act? But what do they think is income? And the age 67 thing blew up in the government's face. They shouldn't be allowed to change fundamental acts of Canada that we should be able to retire on, depend on. That's not the way it's supposed to be. So because they treat it like an ordinary act of Parliament, they can change it, amend it, or whatever. That isn't right. I plan to look up if the Old Age Security Act was like the Employment Insurance Act. As I recall, I'm still looking for verification of where I saw it, but I think the first Old Age Security Act was ruled unconstitutional because the provinces had the authority over pensions. So the government changed the Constitution to allow it to get what it wanted. Now, I'm sure the provinces didn't mind because they got to save money because the feds paid for it. So you're not going to see them kicking up a stink, even if the federal government breached the Constitution, because they didn't want to have to pay for it. I mean, it's obvious. The same thing with the Canada Pension Plan. Canada Pension Plan in 1998, the disability part was gutted. Now, that's one of the things that I want to look up were the provinces consulted? Because if they weren't consulted, there is grounds that you could say, well, in 1966, 64 actually, when the Minister of Health and Welfare, Judy LaMarche, said that the Canada Pension Plan Act would provide help as of right to disabled Canadians. What gave the government in 1998 the right to take away the help as of right and make it conditional? They said that you had to meet certain rules, but they've changed the rules. Now, when I mention my Reserve Force Pension Plan, I'm going to make this my final point. The Reserve Force Pension Plan is like the Canada Pension Plan in that they don't want to pay it. So when I applied, they said, well, you came out medical, and because you were medically released, in order for you to get your medical Reserve Force Pension Plan, you have to apply for the Canada Pension Plan Disability, and then after you're approved, we'll approve you for your Reserve Force Pension Plan, which I said, go fuck yourself. I said, excuse me, but I had to go through an extensive certification of my disability prior to my being medical released under Queen's Regulations and Order 1501. Item 3B. The doctors had to do a Career Review Medical Board, it was called in the old days, CRBM, or an Army Review Medical Employment Limitation Board, in which my attending physician, Dr. Roy Lilly, his initial findings were reviewed by 3 other doctors. And then they could review the doctor's decision, and when he assigned my medical, my MedCat, and they could overrule him and say I could be kept without restrictions. They could say I could be kept with restrictions, or I could be medically released. So I have been certified through the Canadian military, and you want me to go to Canada Pension Plan and ask for the disability part of that, and you want me to go to a new doctor, a civilian doctor, and you want me to recertify my disability when I have already had my disability certified. So I think that you should change your system, and you shouldn't put on the Reserve Force Pension Plan a system that you don't apply to a Canadian Forces Regular Force member. Because under the Canadian Forces Superannuation Act, the definition of disability is when you cannot perform your own trade. So you can retire medically from the Canadian Forces as a regular force soldier, and you will get your pension automatically. But if you're a reservist, they want you to get the Canada Pension Plan disability first. Now, I could go on about that for a lot longer, but I'll mention one point. I like logic. I told them pricks. Let me get this straight. So you have this bridging part of the Reserve Force Pension Plan. So, you know, it's 33% of the other payment. So $150 a month was my pension, and you were putting about $50 a month for bridging in my pension. Now, if I apply for the Canada Pension Plan disability and I get denied, then you don't pay me my Reserve Force Pension Plan, which includes the bridging. So you save on the bridging. But if I apply and I get approved, then you pay me my Reserve Force Pension Plan, but you don't pay me the bridging. So in both cases, you save on the bridging, you son of a bitches. How come that doesn't get through to them? Common fucking sense. In no way do they want to pay bridging. I was a rare person who got some bridging prior to my approval for the Canada Pension Plan, so they sent me a bill for $909 because they said I had an overpayment, and they quoted the wrong section of the Act, which is incompetence, which is negligence. So in the letter in March of 2015, they said, our office, our headquarters, has been advised that you got the Canada Pension Plan disability, and in accordance with Section 15.2b of the Canadian Forces Superannuation Act, which is the bridging part, then you owe us money for the retroactive period, because you got it during the same period that you got both, and in the future we won't pay you the bridging. To which I called them up. And I said, are you nuts? Are you fucking crazy? I said, I was under Section Part 1.1 of the Act, and Section 15.2b, which you claimed is the legal authority to do what you're doing, is under Part 1. So I want you to stop doing what you're doing and follow the fucking law. You quoted the wrong section of the law. It applies to regular force people only, and I was a reservist. Did that go over well with them? Of course not. Got an email later, and they quoted another section of the regulations this time, and I read it as they were wrong. So I told them, I'm sorry, this is not baseball. I'm not giving you 3 strikes and you're out. I'm not talking to you no more about this shit. So I should just sue them, son of a bitches, for negligence, because they quoted to me the wrong section. I was a reservist. My class of service didn't require me to be served full time. And they quoted me about the Pension Act bridging, the Canadian Forces Superannuation Act bridging part, which is only applicable to a regular force soldier. Now that is negligence. They had a duty of care to follow the law. They quoted the wrong law to me. They then caused me a lot of upset, and they have been deducting the bridging ever since. So basically, it's like all those other things. No matter how much you tell them they're wrong, and you prove that they're wrong, they do it anyway. That isn't good for anybody, okay? In a democracy, we're supposed to have reasons. If they had a reason for doing what you're doing, okay? For example, the bridging. If they were saying, and they had some basis to justify it, that, we got elected, we decided that it was good public policy to do this, and, we decided that it wouldn't be good for the taxpayer to have to pay 2 full pensions when you contributed to 2 full pensions, that, that's not good. We'd rather have you pay into 2 and only get 1. Now, if they had the legal jurisdiction over pensions, which they don't, that might be, you might not like it, but they had the jurisdiction to make that law. But they don't. Okay? Pensions are part of property and civil rights, which are exclusively assigned to the provinces under Section 9213 of the Constitution Act. If pensions were income instead of property, they might have a point. But they claim that you're getting too much income when you're getting your money back that you put away. If you put money in the bank, and then you had 2 bank accounts, and then when you took out both accounts, they said you're only getting part of the money out of one account because you had 2 accounts, then you'd say to them, why the fuck did I put money into both accounts? Don't I have the right to enjoy my own property? My own money went into these accounts. Then I need to get that money out. Whatever the reason is, doesn't matter. It's my money. Because the government has been getting away with it for years. Look at that Supreme Court of Canada case on the surplus in the pensions. Supreme Court of Canada agreed to the government that the government owned it. That shouldn't have happened. How could the government of Canada own our property when it is our property? Okay? They're holding on to the money in trust because that's how pensions work. If you work for a private employer, let's say that you had money taken off your check, even though that isn't the case in all private employers. Service alone is enough. So when you go to get your pension, you're supposed to get all of the money that you owed because you served the employer. They owe a debt to you to pay you what you're owed. But the problem is that many people think that the money we get under the Canadian Forces, RCMP, and the Public Service Superannuation Acts, they think because it comes from the taxpayer, it is the taxpayer that has the ultimate responsibility, and there's a duty owed to the taxpayer. When that's bullshit. Because they are once removed from, the employer side of the federal government. So you serve in the military, you serve in the public service, you serve in the RCMP. You get paid. They pay you some for your current service at the time, and they withhold money to pay you at a later date when you retire. Now that money was earned in service, and they are not supposed to reduce it because you have other money that you paid under other acts like the Canada Pension Plan Act, which that is supposed to supplement other pensions. I posted to my group today, and when I was looking up that thing about the old age security, I found a Caledon document, and it gave the Canada's retirement system. And it said what I've been saying all along. I'm only quoting everything I read. The old age security is the first tier of the retirement system. The Canada Pension Plan is the second one, and it's supposed to supplement the first one. And then you get your registered pension plans and the registered retirement savings plans and personal savings as the third tier. And you're not supposed to allow people to transfer money between the tiers because it doesn't serve any benefit to you, does it? So the bridging allows the federal government to save on taxes by reducing their pension obligation under the various superannuation acts. But it's because you get a payment under another act, the Canada Pension Plan Act. So you make contributions to one act because the act required it. You make contributions to the other pension under the other act because the law requires it. And then they say that they put into the law a bridging portion, and therefore we have to reduce one because you get the other. And that's where, as I stated before, but the contract and SISIP taking things into account, they're hoping you won't question them. When you question them, you'll say it's the law. And they're not hoping that you won't say, well, you know, under the Interpretation Act, Section 12, you're supposed to read a law broadly and generously to see what the intent was of that law. So what's the intent of the Canada Pension Plan? It's supposed to supplement the other money that you get. What is the purpose of the Canadian Forces Superannuation Act? The purpose of that is to attract recruits. And does bridging help or hurt the attraction of new recruits? Of course it hurts it, right? And it's supposed to provide a forced savings plan for your retirement. So that's the purpose of the Canadian Forces Superannuation Act. Now, does bridging, Section 15(2)(b) of the Canadian Forces Superannuation Act, does it fit within the overall spirit and intent of the Canadian Forces Superannuation Act? And you can substitute in the RCMP and the Public Service Superannuation Act. The answer is no. I'm not just saying it. I'm saying that when you have two pensions, you have to get two pensions. You can't reduce one because of the other. Either way, A takes B or B takes A. You can't do it. Minister Marsh said it in 1964 on the 9th of February, and she was asked a question by Mr. Chatterton, and Mr. Chatterton said, listen, if we have a public servant who becomes disabled, they're going to get a Public Service Superannuation Act disability pension. Will they also get the Canada Pension Plan disability? And she said, yes, of course. If he has 5 or 6 pensions, he'll get them all. Now, you see, anybody who says that the government intended to have bridging, that statement proves them wrong. They can try to say that they decided to put this in place so that you'd have to reduce one because you got the other one. But you know what she said when she was asked a direct question? No. So why have they been getting away with it for so long? When did Canadian Forces Superannuation Act, Section 15(2)(b) come into existence? Who wrote that law? Was it put in by bureaucrats? Or was it put in by our elected representatives? If it was put in by our elected representatives, it will be a lot harder to fight. But if it was put in there as a means of administrative efficiency that they decided to put it in there, and no elected member of parliament had input into it, then that law is invalid. Unelected people cannot write laws. We elect people to write laws. And then we have people that are supposed to administer the laws. It isn't supposed to be someone at Veterans Affairs decided to put into place a policy like on the 18th of May 2012 after the Manouche case, and some administrator of something, director of something, put out a policy and they said, you know, we're going to prescribe the Service Income Support Insurance Plan, Policy 901-102, as a clawback for the earnings loss benefit. Sorry, you weren't fucking elected. You want to get write laws, you get elected first. You get elected, you write laws. That's your job. You get paid for it. But you're the Director General of something at Veterans Affairs Canada. You can't make laws. You're not allowed to. Now, they could probably talk to the people and suggest to the people that make laws, and they might write laws based on what they suggest or recommend. But you can't put out a policy and treat it like a law. There's a difference between a law, which is mandatory, and a policy, which is a suggestion. Do you get it? I mean, policies and directives and guidelines, they suggest what you're supposed to do, but a law has to be enforced and you have to obey it. See, that's the way it's supposed to work in a perfect world. Now, I'm here thinking I should shut up, but I'm looking at the last little bit. I put a post, in my post I try to put things in just to show you I'm not spouting off shit off the top of my head. Damages are not supposed to be taxed, according to a case I posted an excerpt from, and I put a red box around it. And it's from the Jennings 1966 Supreme Court of Canada case where the subject of taxation came up in damages. And basically they said, you know, get out of my courtroom, this is insane. But you are not supposed to allow the person who did the wrong, who committed some injustice, and then they get took to court. And then the judge agrees that they were treated wrong, because until the judge agrees, well, you're just making allegations. But to take tax into account gives a savings to the person who put the person in the wheelchair, and the person who's put in the wheelchair by the person who makes the savings. Well, that's just not fair. Do you see why? It's just terrible. You can't let someone save money and use tax as the reason. Well, that's the reason I put it there. SISIP, by being taxed. Income replacement benefit, by being taxed. That is giving the government a savings, allowing them to mitigate against the damages that they're supposed to pay. And if you allow someone to take taxes into account to mitigate damages, then you're opening the door up for the same thing to happen in the common law. And most people would agree that they'd probably say, well, something wrong with that. Why shouldn't people be taxed on the transfer of money from one person to the other person? Well, because they're not getting income. They're getting capital payments to replace the capital loss that was caused by somebody's fault. Because if you don't have someone at fault, you don't get damages. See? If you have someone that's been at fault, you take them to court. You can sue them on negligence. You can sue them on misrepresentation. There's all kinds of different torts, they're called. Until you win, it's just an allegation. But once you win, it's a judicial fact. It's a precedent. It can be used in other cases. And no one can argue with you because they had their say, you had your say, and the judge agreed with you. Well, maybe they agree with them. But my point is the thing called judicial finality, and the judge is supposed to be the expert. And after the case is heard, if they make a decision, hopefully it wasn't anything appealable in either way, because they should be getting paid to do their job properly. And again, that brings me back to the Manouche case. The judge erred seriously in law when he tried to say that the Pension Act was an indemnity for injury. A non-indemnity payment, pain and suffering. Because first of all, he was wrong about that. Pain and suffering is still an indemnity. If you get paid a pain and suffering payment, you're getting indemnified for the pain and suffering that was caused by the person that injured you. I think they're getting mixed up with non-economic or non-pecuniary. So they see non in front of it. Non-pecuniary, non-indemnity, and non-compensatory. And they think they're all the same. But they're not. If you lost wages, if you lost pensions, if you lost other stuff, and then you have additional stuff like pain and suffering, all of the payment that you get in a court of law will compensate you for that injury, and it's supposed to be a settlement once and for all, and that's it. So the judge had an idea that because it's tax-free, he jumped to the conclusion that it had to be a non-indemnity payment because it's tax-free. But insurance is tax-free, and they tax it. So you can't correlate taxation to the payment to try to determine whether or not it's income. It's just not possible. What you have to do is look at the fundamental legal character of the money. Why was it paid? Who paid it? What was the basis of the payment? Time for cash for service, time, income. Get injured, sue the person who injured you, get damages. It's damages. Get injured, have a contract of insurance, apply and get approved. Now you have a non-indemnity payment payable in contract because you bought a contract of insurance. And if you hadn't bought the contract of insurance, you wouldn't be able to apply and get the fucking insurance. I mean, it's insane. Last point, I promise, but it reminded me as I was talking about insurance, I was talking to them Yankees, Americans, and Australians, and British guys, and they were talking about health insurance. And they got my back up because Canada has free health insurance. I said, we certainly do not. We pay taxes. So you can't say it's free. And I said, I think people are getting mixed up in insurance these days. Anyway, they think that, like, if you watch that movie, The Incredibles, they think that the insurance company is going to try to use technicalities to try to save when, you know, insurance is supposed to be utmost good faith. They're supposed to look at things and treat you fair. They're not supposed to deny you on technical legalities. But how many people think that's the way it is? Because that's the way it had been operating. I'll give you an example from my own case. We were down in Florida, came home, a hurricane had hit Newfoundland, and the front window had blown out. I had left it open a bit, and the wind took it and slammed it off. Now, I had window insurance on my home, and I thought I'd have a $50 deductible because I had insurance. Oh, no, they said, that's part of the house. That's not covered under your insurance rider that you put in there for glass. That would only be the glass. So if you had glass people come in and replace the glass, then we would pay it. Bull fucking shit. They're not supposed to do it. It's just that I didn't want to go to, I was having too much trouble with veterans and pensions and shit. I didn't go fight with them. But they were arguing a legal technicality to try to save under the deductible. Instead of a $50 deductible for glass, they put the normal deductible of $1,000 on it, and the window was $2,000, so I saved $1,000 in getting a new window, but they saved $950 by fucking me over. Insurance is not supposed to be technical and legal. It's supposed to be equitable. You buy it for peace of mind. So if you have the insurance company try to argue legal technicalities, here's another fine example. Someone rear-ended my vehicle. Young fellow's driving it. Go to pick it up. They said that'll be $1,200 or something dollars. I said, excuse me, but the other person rear-ended my son. Why should I have to pay any insurance when they have to pay the bill because they're at fault? They looked at me like I had 10 heads. They didn't know what to do. They called this one, they called that one, then they fixed it up somehow, but I was not paying for a liability that wasn't incurred by me at my fault. My son's fault. Someone else was at fault because someone gets hit from the rear is 99% of the time they are going to have to pay. Their insurance will have to pay. But you know, I bet many people wouldn't have questioned them. They would have passed out their Visa or paid the cash when they were told, here's the bill, your truck will be paid, you can have it back after you pay. Well, that's the problem. Everybody is thinking about insurance in terms of technical legalities, and they're not looking at, well, what is the justice here? Why should the person not at fault have to pay a cent? Because they would have had their car perfectly fine if the other person hadn't hit them and damaged their vehicle. Why should anything come out of my insurance or my pocket? They could have avoided the accident, and then there wouldn't have been a collision clinic or whatever, auto shop, having to fix the damages caused by their negligence. Listen, talking too long? Thinking about taking a break one of these days, but I'll probably not do it. But I'll try to keep her simple and try to get along, and one of these days, hopefully it'll all get fixed. Thanks for watching. Have a good day.